One of the most interesting notions is this area of in terms of equity and inequality is the issue of prorated benefits. Let's look at that. Merely because you're part-time doesn't mean you're going to be half the person, that you're going to do only half the job. One does not expect that a doctor who works full-time and one who works part-time is going to be less of a doctor. And yet, for part-time faculty in universities, I must say internationally, but in particular at Concordia, we are not provided with prorated benefits. And what are prorated benefits exactly? Having adequate office space to meet our students, having prorated salary rates vis-a-vis full-time professors, having prorated pension benefits, health benefits. I do not understand how this society, which purports to have the Canadian Charter of Rights and Freedoms, the Quebec Charter of Rights and Freedoms, and espouse all kinds of notions about equality, yet has failed to respond to the needs of those who work part-time in a labor market who want and insist on being treated with equality and without discrimination of treatment. Ultimately, not having prorated benefits means we're just merely a side order of French fries. And we have absolutely no equality, equity, in terms of how we are looked upon, how we are respected, and how we are treated. It speaks to unequal treatment, something that part-time faculty members are having less and less ease dealing with. What is a collective agreement, and what is the CUPFA collective agreement all about? A collective agreement is a wonderful contract. It's an agreement between two parties that have reached an understanding about how they are going to be treating each other. Ultimately, the benefits of having a collective agreement is that it removes conflicts and speaks to the need for harmonious relationships, speaks to an understanding, speaks to an interest that we share in common about working conditions, about sound pedagogy, about academic excellence, about academic freedom, about a host of areas in which the two parties are involved with. In our case, it's part-time faculty and our membership and the employer called Concordia University. All our working conditions, these joint understandings, are very, very helpful because they establish labor peace. And that is the purpose of any collective agreement. Now, how does Concordia look at collective agreements? Well, the ink isn't even dry, and they maintain that the collective agreement only belongs to the union, only belongs to the association. They forget that the ultimate purpose is harmonious relations, and they continue to challenge the very things that they had agreed to. And it has been a horrendous experience at Concordia University. They have the reputation for having the longest period in negotiating collective agreements in the entire province of Quebec. They have the most horrendous schedule of arbitration cases. Concordia uses the collective agreement and the law like a gun. And they're litigious. And it helps to explain why much of the money is wasted on hiring gunslingers as lawyers to challenge in the court system and through the legal process the collective agreement that they signed ostensibly in good faith, but clearly not in good faith because of the challenges they continue to raise. So it's not really promoting harmonious relations at all. You can well imagine how frustrating this must be during our current contract negotiations. It's difficult to have confidence in an employer who sees a collective agreement as a position by which they must contest in a manner that is aggressive and very, very costly to the institution and to our members. It would be better for them to settle on a disagreement rather than to continue to waste valuable resources and money. Not to mention the problems of eroding a relationship that is meant to foster harmony instead of one that fosters war.